The Emory University Campus Coordinating Center created these monthly webinar series to share with a broader audience of Southern nonprofit professionals some key information. These webinars were designed for the busy nonprofit professionals on the go to get a quick training and resources to help their organizations function at the highest level. Now, these webinars also are to give people a look at what other trainings we have available here at Compass. Each webinar will highlight one or more of the 8 core areas of our capacity building training. And of course, for more information, we invite you to look at the training section at our website. We're really excited about today's webinar, Compliance, Everything You Need to Know About Following the Law. And we never take that for granted, that as nonprofits, that this is the foundation for successful organizations. In this webinar, we'll highlight a few strategies and tools that all CBOs should know, not only consider for their organization, but also when advocating for policy change within your jurisdiction, city, or state. Did you know that all aid service organizations have to be HIPAA compliant? And as the nation is under a state of emergency, it's also important to know what regulations have been amended to continue to serve clients and provide care. So today, I'm extremely honored to introduce our trainer and facilitator for today, Ms. Sybil Ingram. And Sybil will share with us today regulations and compliance laws and answer questions that you may have. So Ms. Ingram, I'm going to turn it over to you.
Yes, good afternoon. Thank you very much. Can everyone hear me? If you would acknowledge.
I can. I think other folks are muted.
Okay, if they can always acknowledge in the chat area as I have that up. If everyone could just say yes, that would be very helpful. Just so that I can get a check. Kia, thank you. Yes, excellent. Okay, the other thing that I would like for you to do, please, is to write down questions off to the side. And as you have a question, if you could send the question to Darian or Leah while I'm talking so that I can address it toward the end of the presentation, that would be very helpful. Okay? And I'm going to keep the chat up just in case somebody has an urgent question and they need for me to explain something immediately. So I am Dr. Ingram. I have been in healthcare a little bit over 40 years. And in the past 20 years, I found myself working more so in the area of GRC, which is called Governance, Regulatory, and Compliance. And that happened as a result of me having to take on the banner of being the HIPAA person, HIPAA point person with one of the organizations I happened to be working with at the time. And so as a result of me being in the healthcare arena, as a practitioner and non-practitioner, I've always worked in a regulated type of environment. And you too, as a result of you working with the organizations that you represent today, work in regulated environments. And so we're going to talk a little bit we're going to talk a lot about HIPAA today and where it is today and where we see it going in the near future. But let's just cover a few basics about the difference between privacy versus confidentiality, because that's an area that a lot of people, there is a certain amount of crossover there. But I need to have you understand that there is a distinction between privacy versus confidentiality. And you can see some of the distinctions that I've been able to pull from you here. One of my largest takeaways for you with regards to privacy versus confidentiality, that confidentiality is definitely something that's more ethical, something that's driven from an ethical basis, contractual basis. Sometimes there's a general agreement, and sometimes it in the contract will specify it out. I know that you all have worked for a variety of different organizations. Usually they'll have some type of confidentiality clause, and that clause will go back to the code of ethics associated with the organization. Whereas when you agree to keeping information that has been given to you or information that you have been exposed to as confidential, there is the additional layer of making sure that you keep it private. Privacy of confidential information is usually driven by law. It is a legal commitment. It is a legal type of duty that you have. And you know that when you break the law, there are consequences, civil as well as criminal, for breaking a law, as opposed to confidentiality. When you break the confidentiality, you're usually going to break trust. You may have consequences that may lead to some type of litigation, but definitely in the privacy world, where there's been a breach of information that has been identified as being confidential, in 9 cases out of 10, there's going to be some type of litigation that will follow on as a result of you allowing the breach or you causing the breach. And we'll talk a little bit more about that later in terms of your responsibility with breaches. So let's move forward a little bit, okay? Let's move to HIPAA, the Health Insurance Portability and Accountability Act. This act was signed in 1996 by, at that time, the sitting President Bill Clinton. But it did not really go into effect until 2003, 2004, and 2005. And we'll talk about that here a little bit. The Health Insurance Portability and Accountability Act, Title I, most people know as COBRA, and are familiar with being able to have information once they've, having insurance once they've left their previous employer, and the previous employer is required to offer some type of coverage. So that's where the COBRA Act comes into play. We won't talk about the fees and pricing of premiums associated with COBRA, but I just wanted to let you know Title I references COBRA. Title II is where we're going here under the Administrative Simplification Subtitle Act of HIPAA. And this is where we get into the 3 areas of privacy, security, and EDI. EDI standing for Electronic Data Interchange, and it has to deal with transactions, code sets, and identifiers. I'll talk a little bit more about that later. Then there's Title III, Title IV, and Title V, that most people are not aware that there are 5 parts of HIPAA. They believe that there's 1 part of HIPAA, and that's the largest part that we're going to be talking about today. But I did want to make you aware of these different titles associated with HIPAA. I know that some people have heard of HIPAA being associated with the hippopotamus because it was so huge in terms of being able to implement in different organizations' respective corporate compliance departments, security departments, EDI departments. And then, of course, the lawyers in the beginning used to talk about it as being healthy income paying aware attorneys. And so, which was a little joke that was amongst them, but wasn't necessarily amongst the rest of us that had to implement HIPAA in our respective organizations. So let's go on to the next slide with regarding to who has to comply with who has to comply. In the portions of the privacy rule, the security rule, the EDI rule, there are sections in there where everything is defined. And one of the definitions that is very clear and has caused a lot of problems with regards to who has to be compliant with HIPAA is written out under the definition section in each one of the rules as a covered entity. So I want you to look very closely here. Covered entity is a healthcare provider or providers who transmit health information electronically as opposed to manually. And I'm talking about the 1,500 forms, the HCFA forms, the Medicaid forms, those types of forms that we used to use, in connection with any of the transactions identified in the regulation. And so I'll show you what those transactions are here in a minute. Okay, so the first thing is, am I a provider? Number one, yes or no. Who transmits health information electronically? Yes or no. In connection with any of the transactions identified in the regulation, and I'm going to show you what those are. So those are 3 different questions that you need to ask yourself. Okay, so I believe I'm speaking with providers only on this webinar. Am I correct? Could 5 of you all very quickly say yes or no, that you fall into the category of provider? Very quickly, just say yes or no. Okay, all right. That was Gail. I don't believe any of you all qualify as healthcare plans, thank you, Luella, or healthcare clearinghouse. You may qualify though as a covered entity and a business associate. And we'll talk a little bit more about that a little bit later. All healthcare plans are insurance companies that are receiving these transactions identified in the regulation, okay? All healthcare clearinghouses are business associates that are providing services between the provider and the healthcare plan to take the transactions and format them in the ANSI X12 format that is required by HIPAA. ANSI is the American National Standards Institute, and the X12 format is 5010, 5010A currently. It was a different one when HIPAA first started. And then business associates, business associates or anybody that you're going to be sharing the protected health information with. We can talk a little bit more about that. And their business associates. So business associates have business associates that they work with in order to fulfill your requirements of them in the contract. So not only are you talking about the people that you work with as a business associate, let's say something like a medical transcription service, but they also have third parties that they work with or business associates to get things done. A perfect example of that would be some American medical transcription service that you would use to make sure that anything that you dictate gets transcribed so that it goes into some type of electronic record somewhere within your organization. What happened early on is that service was taking that information and sending it to countries outside of the United States that was not under HIPAA and where HIPAA could not be enforced, but the turnaround time was 24 hours or less. So that made them very attractive. However, if a breach occurred in one of these countries outside the United States using the secondary business associate, and the person was harmed here in the United States, prior to 2009, you could not hold the business associate accountable. But now, as of 2009, with the HIPAA High-Tech Amendment or Act, you can hold business associates and their associates accountable. But preferably here in the United States, not outside the United States. So let's move to the next slide. The transaction inventory, okay? In the previous slide where I talked about any of the transactions identified in the regulation, these are the transactions that you would be needing to be sending electronically to a healthcare plan, including Medicare or Medicaid. And if you are a provider, sending any one of these electronically to a health insurance company, then that made you a covered entity under HIPAA, and therefore that meant that you needed to be compliant. Why am I making this distinction so loudly, or maybe a little bit more pointedly? There are other people who have access to information, but they're not sending the information to an insurance company electronically, and they're not using one of these transactions. So let's take a look at the CDC. Definitely falls under privacy rules, but not necessarily HIPAA. Let's look at some schools that have this information that we're talking about. But let's say the school nurse, but she's not sending it to any insurance companies electronically. And the schools, therefore, do not have to be HIPAA compliant. There are other, you can look at durable medical equipment companies. They do have to be HIPAA compliant because they are sending this information electronically to health insurance companies for the wheelchairs and the other devices, ventilators, nebulizers, those types of things that they are providing to people. Look at a medical device company. There's a couple of them that I've spent some time with here recently. The company does not have to be HIPAA compliant, but they definitely have to comply with federal and privacy laws, but not necessarily HIPAA, because they're not sending any one of these transactions as a provider electronically to a health care insurance company. So I just want for you to understand that you would think that anybody that is dealing with healthcare information has to be HIPAA compliant. In most cases, yes, and then in most cases, some cases, no, because of the definition of a covered entity. Are they supposed to keep things private and confidential? Yes. Which laws apply to them when they're doing it? It would be federal and state privacy laws, may not be necessarily associated with HIPAA. Okay, so let's move to the next slide, please. So we have this concept of protected health information in HIPAA. And you can push the button one more time, please. We can see that the protected health information, as we know, is going everywhere. It is generated as a result of a patient seeking a healthcare encounter and receiving treatment or diagnostics associated with the healthcare encounter, preventative types of advice or counsel that you may charge for in the form of a transaction that is going to go over to an insurance company. So whenever there's a healthcare encounter associated with the information that is going to be provided, then that information gets sent, as you can see through the little image here, a variety of different places. It can flow a variety of different places. And so with the information that we're going to talk about here at the data element level in a few minutes, you can see why not only does it need to be kept private, but it also needs to be kept secure. And I'm not going to talk a whole lot about the security rule today, but I do want you to understand that there will be a distinction between what is private, comes under the privacy rule, and then there's the expectation of you securing it. Pretty much like you have all these items in the building where you are sitting listening to this presentation. Some of the things in that building you consider private. The only way that you can make sure that you can keep it private is to put some type of security measure in place by locking the door, locking the drawers, putting it in a shelf, putting it away someplace where things can be, if it's electronic, encrypted, making sure that only certain people have access to it. Those are security measures in terms of keeping what you have determined to be private. And what we're saying is private here, that is going to all these different organizations, is information generated from a healthcare encounter. Next slide, please. So, what is protected health information? Why is it that my name and address and my zip code and my telephone number and all these other things aren't considered protected health information when I'm applying for a credit card or mortgage or trying to get a car or getting on a plane? You know, those types of things. Those types of activities are what? Not considered healthcare encounters. When this information, these 18 pieces of IIHI, individually identifiable health information, are given out as a result of a healthcare encounter, they become protected health information by definition in the law, and therefore are covered under HIPAA with regards to you having to make sure that these pieces of information are not compromised or breached in any manner by you securing them in some way. Number 18, or the last one there, any other characteristic that could uniquely identify the individual. In the 20 years that I've been doing this, that particular one always comes up as a question, as, you know, what do you mean by that? It would mean if there's another number or some other item that you use in your organization that could say that I am and identify me as Dr. Ingram, or could differentiate me from Mr. Darian Bannister. For example, I've worked with different laboratories. When the laboratories are taking in specimens into their organization, they will give it an identifying number. They will give it a case number that is separate from the medical record number that comes in with the specimen, which is different from the insurance number that comes in sometimes with the specimen. That case number or unique identifying code number is another number that they could use to say, yes, that is Dr. Ingram's specimen, that is Mr. Bannister's specimen. And that's an example of any other characteristic that could uniquely identify the individual. So if a few of you all could just say yes or no, is there something that you use in your organizations above and beyond what you see here that uniquely identifies the people that you serve in your organizations? Yes or no? And no one has said yes or no yet. So could 3 or 4 of you all say yes or no? You don't have it, or you do have it? Okay, so I'm assuming that none of you all have another identifier other than the 17 that are here, and 18 does not apply to you. So we will move forward, okay? So let's look at some of the main concepts in the privacy regulation where people will throw, again, words around and they'll think they mean the same thing, but they don't mean the same thing. There's this word called consent. This is where the patient gives you consent for you to treat them, for you to send their information for payment, for you to be paid, and for your healthcare operations, data collection, data aggregation, statistics, metrics that you would use within your organization. These are some of the items that the patient is consenting to, and this will be a part of what is called the Notice of Privacy Practices. We'll talk about that a little bit later. But consent, also the easiest way to remember is the patient giving me consent. Have they given me TPO? Are they giving me the consent to give them TPO, which is treatment, payment, or healthcare operations? An authorization is a form of consent that is required for the patient to give you permission for all other purposes except for public protection. And we'll talk a little bit about the pandemic event that we are experiencing right now, as well as a host of other exceptions. All right, so use is defined as how you are going to use the information that you have been given consent to, or that the patient has authorized you to use internally within your covered entity, your covered organization, or the other covered organizations or entities that you're sending the protected health information to. A disclosure is defined as a release or access or transfer of PHI outside of the covered entity. The covered entities that you're primarily going to be sending the information to, where you don't need an additional consent from the patient, are those that you are sending the information to for treatment, payment, and healthcare operations. Once they have signed that, you don't have to get another consent or authorization or anything for those three activities. But if you're going to do something outside of those activities, then you are considered disclosing their information. And again, it falls under the release, access, or transfer outside of the covered entity. The last thing that I would like to point out to you on this particular slide is the minimum necessary principle. And the minimum necessary principle is key to being aware of whenever you're going to be disclosing information within and outside of your organization. What does this mean? The minimum necessary principle states that you will only give the minimum necessary information requested to satisfy the request where it contains protected health information. So what am I saying? What I'm saying is, if a legitimate entity, or you get a subpoena and the subpoena has to be signed by a judge, it cannot be signed by anything other than a judge in order for it to be legitimate for you to disclose information. If you're going into a litigation type of scenario, you're looking at, when someone asks you to give them some protected health information, one of those 18 IIHI data elements, you want to ask them, what do you need? Do you need name, address, phone number? Do you need social security number and name? Do you need date of birth, the fax number? What is it that you actually need? You do not turn over the entire medical record when you have the minimum necessary principle in play. Am I making myself clear? You don't tell someone how to make a watch when all they have asked you is what time it is. And I want you to kind of keep that in mind as you go forward with regards to when I get a request to give someone their information, ask them first, and you're also going to be documenting the request. Ask them first what it is that they want, instead of handing them the entire dossier associated with the patient, with their protected health information in it. So that is the minimum necessary principle kind of digested for you, and hopefully something that you'll remember going forward. Now, the caveat is if a patient or a patient's legitimate representative, usually the legal guardian in that case, or the person that the patient has appointed, has the right for you to share their information with. If those people say, give me my entire medical record information that you have in place for me, you are to give it to them. You are to give it to them in a timely manner and the law says that's 30 days. You can ask for one extension, which would give you up to a maximum of 60 days to be able to provide that information over to them. And you are not to charge them a fee more than what it took for you to provide them with the information. This is an area of concern where people earlier within the HIPAA implementation phase were charging people extraordinary fees for giving them their information, $100, $200, $500. And the intent of the law that says that you may charge a fee for giving people their information. And again, we've been doing this for 20 years. So a lot of being able to do this electronically wasn't possible in the beginning when the law was written. People were having to go and copy and copy and copy and copy and send this out. What they settled on was you can charge them for the cost of the paper. You can cause them for a fraction of the amount of the ink and toner or whatever you're using, and you can come up with some type of calculated fraction of time that it took of an hourly rate that it took for the person to make the copy. So you are to be reasonable in whatever you decide to charge someone in terms of giving them their information. Next slide, please. So, in the beginning, when the rule first came out in December of 2002, I believe, it was 1,440 pages long. And of course, nobody read it. Everyone was away on holiday. And all of a sudden this rule passed and it just kind of slipped under the door. And what happens is when one of these rules are promulgated, then that means you have 2 years to come into compliance, 3 years if you're a small entity, small group health plan as defined by the rule. So everyone was supposed to be in compliance with this particular rule in 2004. The EDI rule was 2003 and the security rule was 2005. Okay, so there were a myriad of different policies and procedures that came out in the regulation, and there have been some amendments to it along the way, but basically it is still very large. It is the largest of the 3 rules that are in place today. And that's due to, I guess, primarily the lawyers, primarily being the authors of this piece of legislation, and them requiring per law, looking at the USC or United States codes, a lot of this was drawn from that, the privacy codes, and for me to be a little bit more specific, where a lot of policy and procedures were required. Okay, so what I've listed here are just a few of the policies and procedures that are required for covered entities to have. We have the patient's right to access a protected health information, And if you're going to be giving it to them electronically, the little E, that primarily comes up in the security rule, and you'll find that there are many crossovers between the privacy rule and the security rule. So looking at use and disclosures of protected health information with patient authorization. So, there's a difference, again, that I spoke of between when a patient gives you consent and when you need their authorization. And if you go to the HHS site and look up HIPAA, you'll be able to see some of these requirements that are out there for what type of language is expected to be in these policies and procedures. You have the healthcare provider right to deny access to protected health information. There are times where you can use and disclose the information without their authorization, and I'm going to give you a real live example of that later on in the presentation. There is a notice of privacy practices that I'm sure that you all are aware of. This is to be posted prominently in the lobby of your organization, wherever you are receiving patients in, as well as documented so that you can give it to them at least once a year initially, or whenever you have made some type of amendment or changes to it. Again, the language of this is on the HHS HIPAA site that is required. There are business associate agreements. This is required on the EDI side, privacy side, and the security side. And there is a template for a business associate agreement that is free on the HHS site. There are a lot of people out there charging for this. I am suggesting that you not buy the template, but you do pull the language out and you fill in the blanks and have your legal counsel do any type of amendments to it where it needs to be more customized for your organization. Then there are policies associated with research and limited data sets that you're able to use internally or disclose externally to various organizations. Again, the language and the conditions under which the information can be used for research or put into a limited data set where you have information that has been de-identified prior to it being released is also mentioned on the site. Generally speaking, I have books and books and books of policies and procedures that I know have to be written in templates that where people can just fill in the blanks. But I do want to stress to you that writing the policies and procedures to be compliant with this particular rule will take a certain amount of time, and it is not an act that is to be taken lightly at all. Let's move forward, please. So, establishing compliance in your organizations. You are required to do an assessment of where you are with regards to being compliant with each of the rules that apply to you. Again, right now, we're just talking about the privacy rule. So you would do an assessment. What you would do an assessment is you can look through the rule, or there are different assessment tools that are out there and readily available that have been made over the years by a variety of different companies so that you can go through and a checklist and see, do I have these things? The way that you know that you have to have something in the regulation in any law, and this is just, I'm going to give you this little golden nugget right here for HIPAA or any other regulation that you have to be in compliance with. You are looking for 3 words that say will, shall, and must. If there's a statement in there that says you will do this, the covered entity shall do this, the covered entity must do this, that means you will, shall, must do whatever it is requiring for you to do, and you can check that as a requirement, and you'll know that this is something that you have to do. If you're doing a gap analysis and you see will, shall, must, and you don't have that, then that means that you have a gap there in terms of being compliant. That's the quickest way and the easiest way for me to point you in a direction to where you can start looking at, do I have these things in my organization? If you see words like can, may, or should, can, may, or should are optional words, and you can or may or should do those based on the organization requirements, you need to make sure that you've done at least the will, shall, and must ones first, okay? One of the things that you have to have in the law is someone designated to perform in the role as the chief privacy officer. I did not say that this person had to be an attorney, lawyer, or something like that. But the law says, the rule says, privacy says that you will have someone designated in your organization as a chief privacy officer, because when the Office of Civil Rights, who is the enforcement organization for the privacy rule, comes around and does their compliance audit for your organization, the first person that they're going to ask for is your chief privacy officer, or who is the person that is serving in this role for your organization. Can the chief privacy officer and the chief security officer be the same person in smaller organizations? The answer is usually yes, because you're a small organization. The larger the organization is, usually these roles are split apart, and that is one example of where there's a crossover. There's also this crossover between business associate agreements. So one of your homework assignments today, at a minimum, is to make sure that you have identified someone that is the chief privacy officer, and don't penalize that person by being a person that didn't attend the webinar today. Let's be very diligent and very intelligent about who we pick as this person. Same thing for your CSO or chief security officer. And then the second assignment for you today is run, don't walk to wherever you have your business associate agreements or contracts with anybody that you have in your organization. And if you don't have a contract with them today, make sure you identify people that you send protected health information to. I have already given you the 18 elements that you're looking for, that you're sending this information outside of your organization. You don't have business associate contracts with doctors. You're not going to have them with the health insurance companies. Those people are already covered under consent in the TPO portion, treatment, payment, and healthcare operations. So you don't need that. But if you are working with someone outside that's not necessarily, well, that is a business associate that you're sharing the protected health information with, make a list of all those people today. Then you want to go and get the template off of the HHS site and start rewriting all of your contracts that you have to have an amendment that has the business associate expectations under HIPAA added to the contract if they're not already in there. Because that is, I am finding as I continue 20 years later, doing HIPAA assessments and remediation plans for people, that's one of the things that they're all having to do, particularly since the wording was changed. The wording and expectations have been changed since 2004. There are other things that need to be done during an assessment, but in the interest of time, I'm going to move forward. After you've determined your gaps, you want to do remediation planning. Remediation planning means closing the gap between what you're supposed to do and what you found that you haven't done and needs to be done on a go-forward basis. You come up with a plan for how you're going to do that. And you have to do it for each point that needs to be addressed. And then you need to implement whatever your plan is going to be, which includes training. So let's say that we're looking at a policy and procedure that we don't have. We don't have the notice of privacy practices. We need to write the notice of privacy practices. We need to let everyone in our organization know that we have it. We need to train them on it. We need to document that we have trained them, and documentation of training is a requirement under all of these rules. And then you can implement it, and then you will continue to monitor that process from this time forward as long as you stay active under the definition of a covered entity. I'll just use that as one example. You would do that for everything that is required that says will, shall, and must under the privacy rule as a result of what you found in your gap analysis. Remediate that by coming up with a solution, implement your solution accordingly, and continue to monitor it. Next slide, please. So we've got a new issue that was not identified 20 years ago, but was provided for in the regulation, where we will need to sometimes disclose protected health information because there is a national security issue involved, or a public health issue involved on a grand scale. And the coronavirus and HIPAA considerations are one of the issues that is pressing us as we speak in terms of what we can and cannot disclose because of this public health information, and to whom we can disclose the information to because it presents such a threat to the general public health of the populace of the United States and United States territories. So if we go to the next slide, please. This is information that came out this week on the 15th, where the Office of Civil Rights put out an update on HIPAA on uses and disclosures associated with protected health information. And some of these issues you see here have been waived. So the requirement to obtain a patient's agreement to speak with family members or friends involved in the patient care, that under HIPAA, you usually have to get permission, consent, you have to get authorization from the patient to do that. That has been waived now, since they know that there are more than one person within a family that may be affected and infected potentially by this particular virus. The requirement to honor requests to opt out of a facility directory. This facility directory is usually when you go up to the front desk of a hospital and you say, is Mr. Bannister in your hospital? And the person would say yes or no. Under HIPAA, a person, Mr. Bannister in this particular case, could say, I'm in the hospital, I don't want anybody to know that I'm here, and the hospital have to honor it under the HIPAA privacy rule. It has been waived right now in terms of honoring that request. That is what that means. The requirement to distribute a notice of privacy practices has been waived at this particular time. There's information that needs to get out because the general public health of the United States is being threatened, so that has been waived. And the patient's right to request confidential communications, which I know is an area that is very near and dear to your hearts. Normally, if the patient requests that I need for you to keep the information that you're getting ready to discuss with me very confidential. I don't want anyone else to hear it or know about it. And they have the right to request that. Under HIPAA, you have to come up with some type of provision where you can sequester the person off, move them to the side. I know over the years you've seen where in pharmacies they've asked for people to step back, or they've created a place where they can talk to a patient very quietly on the side. Those are methods that people have put in place because of the privacy rule, where the privacy rule says that the patient has a right to request confidential communications. Unfortunately, right now, that right is being waived. Next slide, please. This is a swim lane that hopefully Compass can make available to you. These are different plans, this is a flow chart of how the protected health information may be used for public health emergency purposes. So if you're interested after the presentation, he can make this particular swim lane available to you. I would strongly suggest that you ask for it and see how you are going to implement it within your respective organizations. Next slide, please. This particular slide, I want you all to write down the little link that I have created for you at the bottom of the slide. It's, oh, I see why it didn't work now. It's HTTP, not HTTP. I believe, so that's a typo. Is http:// tinyurl.com/ and I made this portion HIPAAWOS. We call this the HIPAA Wall of Shame. It is put out by the Office of Civil Rights. It is updated every day. And what it basically consists of, where a covered entity has had a breach of protected health information to the tune of over 500 people that they had within their information within their organization, and it was disclosed inadvertently or whatever, they were hacked, a laptop was lost, someone sold it on a USB or whatever, they will publish your name, your organization, how many people were affected, the date that this occurred, and what was the incident that caused the breach to occur. And this is updated on a daily basis by the Office of Civil Rights. You do not want your name publicly shown on this particular page, and people are going to this page to see if they want to do business with you. With regards to security measures that you've put in place to keep their information private or not. So again, it's this is not the real URL. This is just a URL that I've made for you all to get to this page quickly. But if you'll go to tinyurl.com/HIPAA, WOS, and that's called HIPAA Wall of Shame. But that's not the real name for it, but that's what you need to consider it. You'll be able to get this information. Next slide, please. Thank you, Mr. Bannister. Okay, so we're looking at 4 minutes here to go, and I'm ready to try to respond to any questions that you may have over the course of the next 4 minutes. So ready, set, go. Leah and Mr. Bannister.
Thank you so much, Ms. Ingram. Are there any questions? I mean, this has been a very informative webinar, and I think you really closed out with a bang. I didn't know that such a site existed for the Wall of Shame.
They don't call it that, but that's what it is.
Yeah. You know, and of course, it would be our desire that none of our organizations would ever have to, you know, face such
public,
you know, embarrassment about being on that. Yeah. Okay, one participant, you see, yes. One participant wants to know, how can she review their policies? And I'm assuming, Mr. Bannister, their policies being like her organizational policies? Yes, he said correct.
How can they review them? Mm-hmm. Is that the question?
Yeah, that's the question.
Okay, so one of the things that I mentioned earlier was that there's a list of policies and procedures that a covered entity is expected to have. Some of the information for the list is free. I would suggest for you to go on Google and Google different companies to see if they have a checklist of policies and procedures, and then that's one way of doing it. Personally, when I do assessments, I go in and I ask for 80 different documents, just to kind of give you an idea of the volume of documents that we could be looking at here. Usually people will not have all 80, and I never expect for them to have 80. But I'm looking at a major and minor policies and procedures, as well as corresponding forms for people to have to go along with the policy and procedure. For example, you have a policy and procedure regarding authorization for disclosures, and then there's going to be a form that you're going to have to create to be able to give to the patient for them to be able to sign the authorization for you to be able to disclose information. So see, that right there constitutes two different documents. If they are unable to find it themselves, or to do a self-assessment, that is what this is called. There are myriad of consulting companies out there available, including myself, that is willing to work with any organization to try to help them do their assessment, identify their gaps, come up and develop a remediation plan customized for them, and then move them forward into the implementation phase.
All right, excellent. Thank you so much for that.
Sure.
Are there any other questions? Okay. Well, it looks like we are right at our hour. I want to thank you again, Ms. Ingram, for the presentation on today. And we want to thank you all who were listening into the webinar and who asked questions. That's great questions, by the way, to help us be prepared to ensure that our organizations are in compliance with these policies and laws. This webinar will be available on our website for reference. And if you want to learn more about this topic or request a training, please apply on our website at www.gileadcompass.com. And so tune in on Thursday, April 16th. That will be our next webinar, so a little under a month from now. And that webinar will focus on organization structure or restructure, what you should know before doing both. Until next time, have a great day, be safe, and remain healthy, everyone. Good day.